Hi students, in this video we're going to take a look at the case Lockyer versus Andrade. This case is from 2003 and it's a case about three strikes laws. Three strikes, you're out. Okay, bad joke. But that's the kind of issue that we're looking at, and this is one of our first cases as we move into this unit on punishment. And so we're going to sort of use this case to think about what is it that justifies punishment. And are three strikes laws justified given our best theory about why we should be punishing people? Alright, so to start, let's take a look at the facts. Andrade had been in and out of prison for years. So in 1982, he went to prison for misdemeanor theft. Later that year, he was charged with 3 counts of first-degree residential burglary. 1988, 6 years later, he's charged with transportation of marijuana. 2 years after that, arrested for misdemeanor petty theft. 1990, again, transportation of marijuana charge. 1991, he's arrested for escaping from a federal prison. And then he's in prison for a while. He gets out eventually on November 4th. In 1995, he stole $84.70 worth of videotapes from a Kmart. So that was not a great move, but then to make things even worse, a couple weeks after that, he stole $68.84 worth of videotapes from a different Kmart. Now, I think in some sort of independent research that I did into this case, it looks like the tapes that he stole were actually tapes for children, like children's videos. It's hard to know exactly what to take of that, right? In one way, it's like this really kind thing that he's doing for kids, presumably. Obviously, stealing is not a great plan, but maybe it's worth keeping that sort of fact in mind here. In total, right, he stole a little bit over $150 worth of videotapes. Now, because of Andrade's misdemeanor petty theft conviction in 1990, California could prosecute Andrade's 1995 petty theft crimes as felonies, which they did. So, as the majority opinion explains, right, this was kind of like a wobbler offense. So if you have a petty theft crime in the past, then future petty theft crimes can be charged either as misdemeanors or as felonies. And Andrade was found guilty on both counts. So he was found guilty of the theft, the first theft of the Kmart and the second one at the Kmart. They were both tried as felonies. He was found guilty of both. Now, this becomes a really big deal, right? Because California has this 3 strikes law, and according to that law, if someone has been convicted of at least 2 serious or violent felonies, then any subsequent felony constitutes a 3rd strike, which results in that person's being sentenced to serve 25 years in prison. So what's going on here is that Andrade had been convicted of 2 serious or violent felonies in the past, right, associated with robbery, the 3 counts of robbery, right? And then so these felonies count as 3rd strikes. Both of them end up counting as 3rd strikes. So given that Andrade had been convicted, right, of these 3 counts of first-degree residential burglary in November of 1982, both of the 1995 petty theft crimes constitute a 3rd strike, and he ends up being sentenced to serve consecutive 25-year prison terms for a total of 50 years in prison. That's a long time. 50 years in prison for $150 worth of videotapes. Now, Andrade appealed his conviction, but it was upheld by the California Court of Appeals. So then Andrade petitioned for a writ of habeas corpus in federal district court, basically another appeal. Here he argued that he was being held contrary to clearly established federal law, and the thought is that his crimes that he was convicted of were cruel and unusual under the 8th Amendment of the Constitution. So the district court denies his petition, but the 9th Circuit Court granted it and overturned his conviction. So he's convicted in state court, right? He appeals to the federal court because he thinks that his constitutional rights are being violated. The first court he appeals to denies his appeal, but the Ninth Circuit Court grants it and overturns the conviction. And then Lockyer, Attorney General of California, presumably, appeals the case to the U.S. Supreme Court. All right, so the central legal question in this case is, does clearly established federal law prohibit California from sentencing Andrade to consecutive 25-year prison terms? So basically, is this three strikes law that's giving Andrade 50 years in jail, is that a violation of the federal law? And in particular, right, do these punishments violate the Eighth Amendment's prohibition on cruel and unusual punishment because they're grossly disproportionate to the crimes that he committed? And so there may be different ways to divide up that question, right? So one way of thinking about it is a question of like, is this 50-year sentence way too harsh? Or like, is there something wrong with three strikes punishments in general? That's the question at issue. So before we go too far, right, I'd encourage you to think about this, right? What do you think? Does Andrade's three strikes punishment violate the Eighth Amendment's prohibition on cruel and unusual punishment? Does it violate the Eighth Amendment? Because it's so disproportionate to what he did, right? $150 worth of videotapes, 50 years in jail. That's a harsh sentence, right, by anyone's lights, right? But maybe you think, no, that's justified. That's what the law says, and that's what he gets. So think about how you'd answer that. Think about your reasons, right? Why? And once you're done, you've sort of come up with some sort of explanation. Then move forward, and we'll take a look at what the judges had to say. All right. So how did the Supreme Court rule? It was a 5-4 opinion written by Justice O'Connor. Again, right? Divided court. Justice O'Connor is often a tie-breaking vote, so she ended up ruling that the federal law does not prohibit California from sentencing Andrade to these consecutive 25-year prison terms. So the federal law does not clearly say that this is disproportionate, and so they're going to allow it. The reason for this, according to the Supreme Court, is because California's three-strike law does not obviously violate the disproportionality standard that was established in these two cases, Rummel versus Estelle in 1980 and Solemn versus Helm in 1983. So we'll take a look at what those two cases said in a little bit here. All right, so here's Justice O'Connor's sort of opinion, the sort of main points that she's laying out. So first, in the Rummel case, the defendant committed 3 separate offenses totaling approximately $230 in fraudulent activity. That person received a life sentence with the possibility of parole after 12 years for the third offense. So that's sort of the situation in Rummel's case. And the Supreme Court held that that was constitutional, so they allowed that punishment. In the other case, the Solemn case, the defendant committed 7 separate offenses, including third-degree burglary, obtaining money under false pretenses, grand larceny, and DWI. He received a life sentence without the possibility of parole for the 7th offense. Now in this case, the sentence was overturned as unconstitutional. So the U.S. Supreme Court said, no, we're not going to allow this. This isn't okay. And the difference, notice, right, is in the one case, there's this sort of 3 strikes penalty that allows the possibility of parole after a relatively short time, 12 years, and that was okay. But in the other case, where you get this sort of, 3 strikes, 7 strikes, some sort of additional penalty because you've committed multiple offenses, but in a case like that where you don't get the possibility of parole, the Supreme Court's going to say that that's unconstitutional. So if we look at Justice O'Connor's argument, roughly speaking, she's saying something like this. So Andrade's punishment lies somewhere between the two, right? Because what happened in Andrade's case, right? he's given a 50-year penalty. So that's not life in prison. It's not 12 years opportunity for parole. You've got to go at least 50 years. That's, worse than the one that, was clearly constitutional, right? 12 years parole possible. But it's not quite as harsh as the Solemn case where it's life in prison. And so because it's sort of in between there, premise 1 is true. Premise 2 says that if that punishment is in between the two, then it's not obviously unconstitutional. Solemn is unconstitutional when you get life in prison, but Andrade wasn't given life in prison, and so it wasn't that harsh. So it's possible that it's constitutional. It's not clear. So the conclusion then is that Andrade's punishment is not obviously unconstitutional, and that is the kind of argument that his team was making, that it was in clear violation of federal law. And so O'Connor is saying, well, it's not clear, and so it's not necessarily a violation of his constitutional rights. Now, in Souter's dissenting opinion, he's going to be critical of that kind of argument, and in particular, he's arguing that premise 1 of Justice O'Connor's argument is false. And what does that premise say, right? That premise said that Andrade's punishment was somewhere between Rummel and Solemn. But what Souter wants to say is that it's not between those two. It's really like the punishment given in Solemn, which we ruled unconstitutional. So here's the sort of similarities. Both Andrade and the defendant in the Solemn case committed numerous non-violent felonies prior to the crime in question. The defendant in the Solemn case was given a life sentence, and since Andrade was 37 when he committed his crime, sentencing him to spend at least 50 years in prison is effectively a life sentence. So O'Connor sort of emphasizes the fact that, well, this isn't a life sentence, he can get out in 50 years, and Souter's going to say, well, 50 years later, he's going to be 87. If he makes it that long, right, he doesn't have much life left, and so it's effectively a life sentence. Souter also says some other interesting things about how, it seems like maybe there's a problem. Maybe a 25-year sentence would have been okay, but when you sort of count these two petty theft crimes as separate felonies, and then you stack them onto each other consecutively, it seems like there's something especially problematic about that in light of the kind of way that the California is justifying its 3 strikes penalty. All right, so if we look at Souter's argument, he says Andrade's punishment is equivalent to the one given in Solemn. If that punishment is equivalent to the one given in Solemn, then it's unconstitutional, right? Because the punishment in Solemn was unconstitutional. So Andrade's punishment is unconstitutional as well. So at the end, right, I think we want to reflect back on this case and think about, how, given the arguments in better sense for how we might want to think through this case, we want to come up with, reflect on our judgment, see if we still think that it's right. And one thing in particular I want to point out is, even if Justice O'Connor is right, that Andrade's punishment isn't obviously unconstitutional, it doesn't seem like that's enough to show that it isn't unconstitutional, right? In some sense, it's up to the court. This, all these cases in some ways go back to this original issue about how do we interpret the Constitution? Do we need to use our moral judgment? Does the law depend on our moral sense or our moral intuitions, or is there we should be legal positivists where the morality has nothing to do with this? In some sense, it seems up to the court, right? So they said that this one kind of punishment is unconstitutional, this other one's not. This case lies somewhere between those two. I think that that's roughly correct. It is somewhere between those two. Maybe it's closer to Solemn than it is to the Rummel case, and then maybe we should just think, well, the court gets to decide where are we going to draw the line? How harsh of a penalty is too harsh? So you might want to think about that, right? Um, at what line, whether you think the court's right or wrong, at what point would a crime or would a punishment become too severe, so severe that it counts as cruel under the Eighth Amendment? And I think this raises a kind of like central philosophical question in the case, and that question is this: something like, are three strikes punishments, like Andrade's punishment, morally justifiable? Is it okay to punish someone very severely if they're a repeat offender? Is it okay to punish for someone's punishment to be sort of out of alignment with the crime that they committed? That's the question that we're forced to ask in this case. And as we look in future lectures, we're going to look at some different theories of how we would justify punishment, why it is that we're punishing people in the first place, and we need to come up with a theory, an account of like why we're justified in punishing people. Once we have that theory, then maybe we'll be able to do a better job of answering a question like this one. All right, that's it for today. Have a good one.